All right, good morning, everybody. Welcome to Jill Carr. We have a number of alternates that will be seated. Representative Grota for Senator Whitley, Representative Hacken Phillips for Senator Hatch. Representative, I hope I got it right. And Senator Gray for Senator Innes. So we have.
Take your pick.
I did.
No, to Jim. say.
It doesn't much matter. Yes, here we are. And Senator Ward will be joining us shortly. All right. To review the minutes, is there a motion? All right. Representative Grota moved to approve the minutes, seconded by Senator Lang, and there's Senator Whitley. All right. In that case, Representative Grota, you're on deck. Fine. Okay. Any comments or corrections on the minutes?
Move to approve.
It's already been moved.
Oh,
Thank you.
sorry.
Those in favor?
Aye.
Opposed?
Madam Chair, I
Yes.
believe it was Representative Grota who initially made the motion, so if she's now on deck, I think the motion has to be made again.
Representative Schmidt has already made it again. So we're covered. Okay. We have a couple of items to postpone. There's item 3D and 3G. The from Human Services, and they're both from HHS.
And Madam Chair, just so you are aware, on item 3A, 2023-12, the board has also asked for that to be postponed so that they have time to file a conditional approval, and that will need a jail car deadline as well as
A
item.
waiver, okay. All right, so
B,
we have
thank
three
you.
items to postpone. Would someone like to make a motion?
Madam Chair, I move that we postpone all three items, with item 3A being waived for terms and conditions as well.
Yes, Representative Schmidt.
Second.
Okay, second. Any discussion, comments? All right, those in favor?
Aye.
Opposed? All right. The consent agenda. Are there-
Madam Chair,
Yes.
on the agenda, item R has a late filed conditional approval, so the committee first needs to vote to accept that late item, and then they can move to vote on the consent agenda. The
Which one is this?
item R,
Oh, the from Employment Security.
yes, ma'am.
Okay, that has a corrective action that is,
A conditional approval request that was late filed, yes, ma'am.
all right, so will need a waiver on that as well, correct?
Just need to vote to approve the late filed item first, since the agency didn't file a waiver of the deadline to file. And then once you vote to approve that, then you can move to approve the consent agenda.
All right, so moved.
Second.
Is there any discussion on the employment security conditional approval? All right, seeing none, those in favor?
Aye.
Opposed? All right.
Madam Chair, I move the consent agenda as amended.
Second.
Any discussion, comments, or anything else to be removed? Seeing none, those in favor?
Aye.
Opposed? Okay. Thank you all. Yes, Representative Grota? Oh, no, you're just reminding about that. All right. On the regular agenda, the Board of Medicine.
So these rules have to do with the physician assistant rules. It is the Med 600s. An amended conditional approval was filed, but there were still a couple of questions that were remaining. One was that we still had not received a copy of the initial application form. It is the universal form that the OPLC has been using, so that wasn't so big of a problem, but we did receive an actual copy of it yesterday. But the other issue was that their renewal form is on their portal, so I was not able to see how it looked on the portal as compared to the universal renewal application. Looking at my inbox, it seems as though that was submitted this morning, but unfortunately I have not had an opportunity to look at it quite yet. And in addition to that, there is a note to jail car on page 3 of the amended conditional approval text. That section had initially been in the initial proposal, but then was taken out in the final proposal. However, it being reinserted in the amended conditional approval, pretty much verbatim for what the statute says, addressed my concern that it had been removed in the first place. The next comment has to do with the fees. On page 4 of the amended conditional approval text, there's an unclear comment because these rules are adopting the PLC 1002 fees, which there is an informational note that I won't get into at this time. But additionally, there's current effective rules, the Med 306.01 rules that currently list the fee for initial application as $115. The PLC rules list it as $175. So there's a conflict there. But then additionally, I wanted to bring to your attention that currently the Board of Medicine's website says that the initial application fee is $203. So we have 3 different fees for the initial proposal. And just on that note, on page 5, there's the same issue with the renewal fee. They're adopting the PLC rules, which list it as $175. The Med 306.01 rule lists it as $65, and the website lists it $203.
I'd like to hear from the agency on that issue.
Thank you. Madam Chair, members of the committee, Lindsay Courtney, Executive Director, Office of Professional Licensure and Certification. So currently the fees that were recently approved by JailCar related to the PLC 1002s established the fee of, I believe it's $175 for physicians. But the 1001s, which were previously approved by JailCar, established a fee of $28 for the professional health program, which is a different fee that we are required to charge. It's a mandatory fee required by statute. And so we've gone back and forth about how to essentially communicate this fee to licensees because there's been a lot of confusion as to what the total fee is. And if we don't specifically list, in the past, we have listed the fees separately, and then people will send in 175, and then they don't pay the 28, and then we aren't able to issue the license. So the 203 is the 1002 fee plus the $28 PHP fee, which is in the 1001s.
Okay, that explains 2 of them. What's the third fee?
So they're currently effective medicine rules that list out a different fee. So that particular rule lists not only the initial and renewal, but all the other fees, which is what I assume it hasn't been repealed on an expedited basis yet, but I will let the board confirm whether my assumption is correct.
Yes, correct. I think the committee is aware that there are conflicts in rules regarding fees. We have attempted to start the process of cleaning that up, but the first step of that process was to adopt a universal set of rules applicable establishing all fees, which was the 1002s. So as we move forward with rulemaking for each board, we will be cleaning that up, hopefully with a citation incorporating the PLC 1002s. But certainly as it stands right now, there are conflicts in rules. There are also conflicts in statutes as it relates to OPLC's authority.
All right. Representative Leon?
Thank you, Madam Chair. Looking at the scope of practice one that was added back in, that looks like that's Rule 306.01, which is the one that currently is the licensing fees. I'm curious that if we adopt these rules, does that mean that the Med 306.01 fee schedule will be deleted from rules?
I will have to re-look at the rule real quick, but these should be the Med 600 rules, not the 300s.
Sorry, not enough coffee this morning.
That's okay. But just to confirm,
That's correct.
yes, okay.
All right.
And
Good,
then
one problem solved.
And then the last comment that I had on this particular proposal is on page 6 of the amended conditional approval text. That particular rule has to do with supervision of physician assistants, saying that they will be supervised by a participating physician. However, earlier in the rules on Med 602.03D, that gives a specific exception to supervision, which is if the participating physician either leaves the practice or is unable to practice due to illness, they have 30 days. So that exception just has to be incorporated in the supervision rule that requires supervision.
Okay.
Tina Kelly, Office of Professional Licensure and Certification, and their suggested rule change language for that, which we will add in.
Okay, thank you. Any other questions, comments? Representative Leon?
Thank you, Madam Chair. If there is no supervising physician with a physician's assistant because of those, do they need to notify the patient that there's not a supervising? I just don't know if that's going a little further afield.
So the statute's silent on that. There is a statute that does allow a physician assistant to practice for 30 days without supervision if those two circumstances occur, but it's silent on whether or not the patient has to be notified. So, and I'm unaware of if the board has additional rules on that.
Ms. Kelly, do you know if there are any additional rules on notifying patients?
Not that I know of.
Okay.
And I would just add for context that there was a legislative change. I believe it was last session. There used to be required explicit supervision and they'd have to register with the board, their supervisor. There was a legislative change that allows the PA to essentially practice independently with a collaborative practice agreement. But there does not appear to be in statute a requirement that the patient be notified.
Okay. Questions? Senator Gray?
I move to approve with the amendment.
Okay. Any further discussion? Seeing none, those in favor?
Aye.
Those opposed? All right, and thank you very much for the clear explanation of the different fees.
Madam Chair,
Yes,
I'm sorry I didn't mention at the outset, but our stenographer is absent today. She's hosting her son's wedding. So she will be doing the transcript from the video and from the minutes that we create. So it would be very important for everyone to speak into the microphone so she can hear the video.
thank you for the comment. All right. Pease Development Authority.
So these have to do with the PDA 600 rules, state-owned commercial piers and associated facilities. The agency did submit a conditional approval that addressed quite a majority of the comments. However, there were still some small discrepancies between the rule text and some of the forms. There were a number of forms that were submitted with this particular proposal. So I have talked with the agency. They have agreed to make changes in order to address those discrepancies. So if it is all right with the committee, I would like to go through each of the discrepancies and then just give a potential recommendation for a change. And if the committee and the agency agree on that, then the committee can vote to approve this rule based on the conditional approval filed and then based on the amendments talked about in the oral testimony.
Okay.
So to start on page 4 of the conditional approval text, having to do with the annual peer use application and permit. At the bottom of the page, the form asks for peer use location and whether a SCIF permit is required. OLS is suggesting that these requirements be added into that section in the rule text. The next one is on page 5 of the conditional approval text regarding the single-use peer permit application form. The form asks also for the peer location and whether or not the applicant wants to use their mailing address or permanent address as a means for receiving communications, but that's not in the rule text. So OLS is recommending that these two requirements also be added into the rule text to address that issue. Also on page 5, regarding the annual birthing permit application and permit form, the rule text asks for a business fax if the applicant has one, but there is nowhere on the form where this is required. As the previous forms don't have this requirement, OLS would recommend that they just delete this requirement from the rule text. Additionally, for that same form, there's a minor discrepancy between the rule text certification language and the certification language on the form. The form in one place says my placement, but the rule text just says placement. So OLS would suggest that my be inserted into the rule text before placement in that section. Just two more. On the bottom of page 5, regarding the daily seasonal parking application and permit, the form asks if the applicant is applying for a seasonal overnight in the parking for section. This is not a requirement in the rule text. And additionally, there is also another form that is specific for seasonal overnight parking. So it's unclear why this requirement is on the daily seasonal parking application form as well. In order to address that, OLS would recommend that selection, the seasonal overnight, just be deleted from the form so it's clear that there are different forms and also it's consistent with the rule text. And the final comment is at the bottom of page 6 regarding the seasonal overnight parking application and permit. The rule text is still asking for the applicant to include the season for which the seasonal overnight parking is sought. However, the form doesn't have a place to indicate that. Instead, it only says that the season shall be from April 1st through November 15th, which is found under the fee section on the form. Based on that, OLS assumed that there was only one season for which can be applied for this particular permit. So OLS would recommend that the rule text be amended so that that requirement's deleted. And that is all that I had for this particular proposal.
Okay.
Good morning. For the record, Gino Marconi. I'm the director at the Pease Development Authority Division of Ports and Harbors. And we've been working with the office on making these corrections. They have a better eye for it than we do, so we have no objections to any of these, Madam Chair.
Thank you. That's good to know. Are there any questions or comments from the committee? Go ahead.
Move to approve with the edits OLS requested.
Second.
All right. That was I heard Representative Schmidt first, but I could be wrong. Oh, Representative Lind, sorry. It was off that away. Oh, okay. Is there any further discussion? Seeing none, those in favor?
Aye.
Opposed? All right, and thank you for your efforts.
Thank you very much.
Okay, we postponed the radionuclides. All right, Health and Human Services.
So this has to do with family-centered early supports and services, the HEM 510 rules. A conditional approval was filed with the division, with OLS, but there was one additional comment that needed to be addressed there were two comments that need to be addressed, but one, the department filed proposed language with us yesterday, a copy of which I have placed at each of your seats so you can take a look. Having to do with HEM 51014, they have inserted new paragraphs G and H, which addressed my initial comment on the conditional approval text, and therefore I have no further comment on that particular issue. So the only remaining issue I had was on page 37 of the conditional approval text with regard to the waiver form. In the rule text, it says that the area agency, the FCESS program, parent, or a provider may request a waiver of a specific procedure in this rule chapter. However, when you look at the waiver form at the very top, it's next to the second asterisk. It says that waivers shall be submitted by the area agency only. So there's a conflict between the rule text and the form that needs to be addressed. I have talked to the agency about this issue, and they represented that they were going to go through an expedited revision to forms process to amend this form, as it also relates to 19 other different rules. So they couldn't address it with this particular proposal, but they are planning to revise that form and have represented to me that they are going to delete that area agency only language, which would address the comment. But at this time, there's still a conflict.
Good morning, Allison Radmay, Administrator for the Administrative Rules Unit at the Department of Health and Human Services. I just quickly want to address the waiver form for BDS. That form is actually going to be filed today for the expedited rules revisions process. I did get approval from the program last night that all looked well to file. Like Attorney Record had said, it does touch, actually, I recounted 18 rules that the Bureau has. And we have removed agencies only as being able to submit the form, just because it really does, cover a wide variety of people or individuals who can submit the form, including staff, area agencies, parents, anyone who the rule applies to. So that will be filed today.
All right, thank you. Other questions?
Move to approve?
Okay, that's moved to approve with the
At the edits.
understand it with the edits, and
And the
that the
understanding.
form will be corrected. Okay. Any further discussion? Those in favor?
Aye.
Opposed? Okay, moving right along.
Madam Chair, I move we reorder the calendar and push DES to the end.
Yes, we'll do that. So we postponed the other HHS rule, Fish and Game.
Okay, so these rules are on the interference with hunting, trapping, or fishing. They're new rules, and they establish a prohibition on interfering with hunting, trapping, or fishing. The statute was enacted in 1989 and amended in 2016, but it appears that this is the first time that the agency has moved forward with rules. It may be that they didn't have reason to do so. I'm not really sure. The statute does require that the agency adopt rules to administer it. You do have a copy, I believe, of the statute at the end of your packet. But anyway, that's the only issue with the rule. And so you may have some questions about the delay in bringing the rules forward.
Good morning.
Good morning. I'm Marty Mobley. I'm the legal coordinator for Fish and Game, and with me today is Captain Michael Eastman. Apparently, neither one of us were working at the department in 1989, so we don't really know why no one adopted the rules at that time, but we do have authority in the statute to enforce the statute, and it has recently been discovered that the rules were not implemented according to the statute. We've been criminals since 1989 and not abiding by the statute. But so I've set about rectifying that situation and proposing to adopt the rules so that we're no longer in violation of the law.
Any questions, comments? Representative Lamb.
Thank you, Madam Chair, and thank you very much. As a landowner that has land open to hunting, I just want to clarify that lawful hunting would only be those with permission of the landowner, and we wouldn't need to exempt them in rules as well. Or should we exempt a landowner if somebody is participating in unauthorized hunting? Or
This would
trapping?
not exempt you from not allowing certain persons to be on your property at all. This would speak about harassment of hunters on open lands.
Okay, thank you.
Thank you.
Anyone else? All right.
Move to approve.
Second by Senator Gray. Any further discussion? Those in favor?
Aye.
Opposed?
Thank
All
you.
right, and congratulations on having some new rules.
Mhm.
All right, OPLC.
So this is an interim rule that was filed by the OPLC regarding license by endorsement. The OPLC had filed a conditional approval and then an amended conditional approval, which resulted in me just having two remaining comments. The first is that informational note regarding the PLC 1002 rules, which I won't get into. But the second comment is regarding the appendix. And I want to start by clarifying that the appendix is normally just an editorial matter that is addressed either at adoption or during certification. However, in this instance, we would argue that the board statutes that have certain statutory requirements for licensing should have been included in this particular appendix because the statute had required OPLC to adopt these rules in consultation with the boards on what would be substantially similar to the New Hampshire requirements. So if there are statutory requirements for certain professions in New Hampshire, anyone who is trying to get a license by endorsement should be aware of what statutory authority their requirements are being compared to. So because of that, we would say that this is technically a violation of RSA 541A8, which requires adherence to the manual requirements. And the manual is very clear that any statutory authority that is being relied on needs to be reflected in the appendix. And to just further this point, I pulled an example from the MLADAC statutes. RSA 330C16 requires that MLADACs have at least a master's degree. And in looking at these rules, that requirement is also in these rules at PLC 313.13. And in looking at that section as well, the statute for the definition of clinical hours, or I'm sorry, core hours, is in that rule as well. They specifically cite that statutory definition by referencing the statute. So that should at least be apparent in the appendix. And that is the only comment I had on this proposal.
All right.
Thank you, Madam Chair. Lindsay Courtney, Executive Director, OPLC. I think we can resolve the issue with the appendix, but I think we disagree that the manual is clear. And having reviewed the manual, in particular, Chapter 3, I think it's 2.4, regarding the cross-reference table, directs agencies to identify the specific provisions of state or federal statutes or regulations that the rules in your proposal carry out or implement. And I would submit that what we are implementing is a statutory authority granted to the OPLC. Now, certainly that's statutory authority. In order to implement that, we have to look at other resources, which would include state statutes, but which would also include state rules, which would also include other extraneous materials explaining, exactly what licensure means in our states and in other states when we do that analysis. The office is particularly sensitive to any attempt to claim for the office to claim authority of the boards that does not belong to the office. I think the committee is particularly aware of the sensitivities surrounding this issue, as we've seen numerous proposals come out throughout the years regarding which regulatory body should have authority to conduct a particular activity. So absent the committee asking us to include this in the appendix, we do not think we are legally obligated to do so according to 548 and the manual. And also, we would prefer not to do so, recognizing that the boards have retained certain authority and that that authority belongs to them.
Committee? Yes, Senator.
So you say that, how would including this information in the appendix in any way detract from the authority of the boards?
So it's not necessarily a rational position, but anytime the OPLC has basically stated that we have the authority pursuant to the requirements granted to the board, that is not viewed very well by the boards, who are particularly sensitive to retaining their authority. So I'm not saying it's a rational thought, but I'm saying that I think the office has to be particularly sensitive to that as we work to collaborate with the boards in partnership. And we do not want to appear to be trying to usurp their authority. So I mean, at the end of the day, if the committee thinks we need to include it for transparency, then we certainly will. Legally, I disagree with OLS's analysis, at least to the extent that they're saying that the manual is clear. I do not think it's clear. But I always want to weigh on the side of being cautious and not trying to overstep the bounds of the office's authority versus the agency's.
I also just would like to clarify one point that was brought up by Director Courtney. The manual doesn't require that every single potential resource that they rely on has to be in the appendix. It is only state statutes and then federal regulations. So those are the only two that need to apply for the appendix.
Okay, and I can agree that there's probably statutes and rules all over the place that might affect these, but it seems to me that someone coming in and looking at these requirements might want a link to where the board requirements are, because and that's what strikes me, whether it's in statute or rules. You want to say what we require of our applicants and what we require of people by endorsement. So that would make sense to me, at least.
I think it makes sense, but I think without the committee saying that this is what we'd like you to do, I think given the dynamics surrounding this transfer of authority, the office was not inclined to do that.
Okay.
I think they need to be transparent, Madam Chair, and put the information in the appendix. Like we said in the comment, we could ourselves amend that appendix. It is an editorial matter. But we'd much rather prefer that they do it.
Okay, so
Madam Chair.
yes.
So a couple things. This is also an interim rule, and you're going to go into
Correct.
full-blown rulemaking. This is to implement legislative changes that just were enacted, that you need to enact rules in order to enforce.
Correct.
Things, again, like that, the endorsement, the substantially different to allow out-of-staters to be able to come in and practice in the state of New Hampshire. Is that correct?
Yes.
And you are planning on going to full-blown rulemaking to smooth out these differences, if you will.
And also to include a number of other professions.
Right.
Certainly.
This is only a start.
Right.
Correct. We're currently working on rules right now, and which would expand the professions that are included. But essentially what we did is we looked at where are we going to get the biggest bang for our buck, so to speak? Where do we think the current endorsement criteria is maybe too onerous, and maybe we can, or conversely, where do we have workforce shortages that even a small change in the criteria, we would see a benefit in this state. So we picked a handful of professions.
Except look at, yes. Okay, anyone else?
I just also want to make as the committee is probably already aware, but everyone aware that we are in the process of amending our manual because we have had a number of statutory updates this past legislative session. So if there's any recommendations or anything that agencies or boards are concerned about, certainly they're more than welcome to submit to our office, and we'll try to include those in the changes. And additionally, the manual will become before the committee with those changes for public viewing.
Okay.
And Senator Lang is absolutely right. The change to the appendix can be made during regular rulemaking. They don't need to do this now.
Okay. Well, we will, in that case, not insist on anything for the interim rule, except that I believe we have some comments from the public. Mr. Rancourt? Oh.
Thank you, Madam Chair. My name is Stephen Rancourt, licensed electrician in the state of New Hampshire. We just had some concerns and we're passing out some wording. We're not really sure, like, with regards to our discipline, what the actual wording is going to be. I don't know if you have it in these interim rules. We submitted this back in beginning of September to the OPLC lawyer, Gretchen, and the suggestions. It went in front of our board last minute at the last meeting, and they had agreed with this changes. So this interim rule process seems to be moving along like with no gap stop, and it's kind of concerning. Someplace like us, as far as the profession, who already reciprocates with almost 22 states, has a pretty good guideline, is very open to reciprocal. We have no issues with that. We encourage that. But we don't want it so that these rules make it harder for somebody who's living in the state to get a license than somebody outside the state. Some simple things, it was missing the schooling. It was some reference to the hours. They had 4 years or 8,000 hours, but you could work part-time for 4 years and not gain the 8,000 hours. So there was just cleaning it up, and there was some information about the schooling that's required for us. To us, the substantially equivalent would mean, for example, we require 576 hours of schooling. If they had, 550 or something there, that would be substantially equivalent. If they had, 7,900 hours, you know what I mean? That would be, but not having it so that they may only have a 2-year program or half the schooling or half the hours and stuff. So we would suggest and ask the committee to accept this as the interim rules going forward for at least PLC 1323.
And I'm sorry, Mr. Rancourt, first off, can you spell your last name for me?
Sure, it's Rancourt.
Thank you. And I just want to clarify, this handout you provided, are these the suggested amendments your board is asking be incorporated, or was this just taken from what is already in the proposal?
So I don't know what you're actually looking at for wording now, because again, lack of communication, we have no copy. It was suggested, this is what we're suggesting should be the full wording. It had some of theirs in there, and we took from that, but I don't know what you're looking at now for.
From the original rule, for the journeyman, they add the new, number 1 is new. Number 2 is amended to delete the years and simply concentrate on the hours. 3 is new, and 4 is the same as the rule.
And if I may, Madam Chair, number 1 was put in there because we have agreements with them, so it's just clarifying it, that we have reciprocal agreements with states already, that they would obviously get the license by reciprocity without anything else. And then,
Okay. I have one question. I know that Maine has a residential-only classification that is not considered equivalent. What in this would invalidate that position?
would validate or invalidate?
Invalidate.
Well, typically they're limited license, they kind of call it, which is less hours, half the schooling.
Ah, okay.
It's
So
kind of how they would do
So
that.
it doesn't meet the hours of the
No.
schooling. Okay, thank you very much. Any other questions or comments from the committee? Yes, a motion.
I guess I just have a procedural question. So, again, I think that these type of changes belong in a regular rulemaking process and not necessarily here at JALCAR to institute new rules that haven't been vetted by anybody, other than what we're hearing today. So I guess my question is, have you brought these to the commissioner, and have they seen them did they consider adopting them, or were they just not in the public in whatever process they had for creating the interim rule?
When you say commissioner, you mean Lindsay, the executive
Lindsay,
director?
Executive director.
I reached out to the OPLC lawyer who was dealing with it, Gretchen. I had correspondence back and forth. She sent me the information. I sent back the suggestions. She said she was going to give them to Lindsay and Doug, and no one ever got back to me as of even the other day. I had checked in with her, and she had no information or responses. They presented this to the board. Wasn't on the agenda, last minute, right before the meeting was going to cancel, to try to get the board's approval, and it didn't go well with the board. So this is supposed to be in consultation with the boards, but the board suggested what you see in front of you and gave that to the lawyer representing our board to bring to them. And again, crickets. So
Okay. Thank
I've
you.
tried.
Thank you, Mr. Rancourt. Director Courtney?
And before the director speaks, I just want to let the committee know that the statute does say that this, in order to establish requirements that are substantially similar, the OPLC does need to consult with the board. So that is in the statute.
Thank you. I appreciate Mr. Rancourt's comments, but I disagree with the characterization of the process. I also want to clarify that Mr. Rancourt is not on the electricians board. And so procedurally, what happened is prior to initiating interim rulemaking, we came up with a draft. And as the committee is probably aware, this is a high priority of the governor. We were asked to move this along in order to make some changes in our state with respect to workforce. And so the agency made this a priority and picked certain professions, again, that we thought we could essentially create a more streamlined requirement. So as soon as we had a proposed draft, we provided to the board administrators who provided it to the boards. Now, it's our expectation that the boards, if they view this as important, will take a look at this and decide to convene a meeting if they so choose to do so. The electricians board did have a meeting with their regularly scheduled meeting. It was on the agenda. And they agreed with the feedback of Mr. Rancourt. I am aware that our attorney has communicated with Mr. Rancourt, so I disagree that there's been a lack of communication there. But specifically, I can't confirm that what we discussed in our office was communicated to him. So I apologize to Mr. Rancourt if this is the first time he's hearing this. But essentially, with respect to the electricians board, we pulled up the statute, which is licensing requirements. And what it says is, after June 30th, the board shall issue a license as a master or journeyman electrician to any person who files an application and meets the following qualifications. Completion of 8,000 hours of service as an apprentice. The board may give credit towards such service for satisfactory completion of a course of instruction in the field or school recognized the board. This particular statute does not appear to require the education that is proposed. And so when we talk about what's substantially similar, I personally do not think that imposing an educational requirement is actually statutorily mandated by our statute. And so therefore we chose at this time not to make changes to our interim rules, but I think certainly we can go through the rulemaking process, the regular rulemaking process, and continue to confer with the boards.
Motion?
I move to approve the interim rule as presented, with the comment that please work with the boards to make sure that future rules
Certainly.
that are coming forward for final rule are a little more cooperative.
Certainly, Senator.
Second.
Second by
It's a question
Representative
over here
Lamb.
somewhere.
Representative Chandler? Oh, so
Yes, thank
Senator
you.
Chandler.
Thank you. I just want to, if we do approve this interim rule, I just want it noted that although we may not ask for the inclusion of certain items in the appendix at this time for the interim rule, that should not be taken as meaning that we do not think that they should be included in a final rule.
Agreed.
Yeah, I agree with that
Yes.
completely. I think the point about having the reference being helpful to people that are applying is important. So I think that for the final rule, it should be in there.
Okay.
Understood.
Representative
We will
Grodd.
make that change.
So having discussed this many times within the EDNA committee, I think it's important that there are many legislators who feel that although OPLC has the authority, they also need to work in cooperation with boards. So I just want to make sure that, because that's going to be something I'm going to be looking at in the future in rules. So that has to be evident, and it has to be transparent.
Certainly, Representative, we would agree that, if I may just comment, we are happy to cooperate, but I think it's very difficult. And for the most part, we have very good relationships with most of the boards, but it's certain boards are very hesitant and reticent to change and are not interested in cooperating with us. And so our concern is that we can't drag rulemaking and implementation of our statutory directives because the boards are not coming to the table. I'm not making a representation that that's a problem with respect to this rulemaking, but it's generally an issue. So I also think that the expectation should be that boards partner with the office in order to implement the statutory directives that the office has.
Okay, thank you. Any other comments? All right, those in favor?
Aye.
Opposed? Okay, thank you very much, and have fun with the full-fledged rulemaking. Okay, let's moving on to DES.
Okay, so 2023-137, fines relating to hazardous waste management. These rules establish fines for violation of hazardous waste statutes and other rules. The rules expired in 2008 rather, and the statute does require the agency to establish fines via administrative rule in order to enforce that statute. The agency stated in its notice that it received advice from the Attorney General's office that it could enforce the expired rules. However, the agency doesn't state whether or not they received that advice prior to or after the amendment to 541A that explicitly prohibits the any agency from enforcement of expired rules for any purpose. The agency states in their response to comments that they have been enforcing the rules, that they've been continuing to do so, and they've been proposing fines under the rules using those rules as guidelines. So clearly, the agency has violated 541A 22 on not enforcing expired rules. And certainly the agency's actions are not in the public interest, and they may not be fair or transparent, but those actions don't qualify as a basis for objection. And the reason why we say that is because the language in the statute says that the committee may object to a proposed rule if the rule is beyond the scope of the authority, contrary to legislative intent, determined not to be in the public interest. It's pretty clear. It says the proposed rule. So here, what we're talking about is past agency action in violation of 541A 22. So, we understand this result is a little frustrating, and staff are looking at 541A and the jail car rules to recommend some amendments to address situations like this. And we're thinking at a minimum of requiring the agencies to provide a report of all the enforcement actions taken, fines or fees assessed during a rule's expiration. But anyway, that's the only issue with this proposal. And with that, I'll let you ask your questions.
Madam Chair,
Director?
I would add to what Kim has said, in that the notice also indicated that the department was using two specific internal documents to determine whether or not to impose a fine. That means those documents contain at least some rules, and they cannot incorporate those by reference, and they're obviously not laid out because the rules are expired.
All right. Thank
Hello,
you.
Pam Monroe, appearing for the Department of Environmental Services. I'm the legal unit administrator.
My name is Kerry Barnsley. I'm a staff attorney. I work for Attorney Monroe.
One part of the explanation I would like to point out at the outset is that I came to the agency in 2020, and during the pandemic, now Commissioner Scott suspended the imposition of administrative fines when vaccines came out and things started getting back to normal. We commenced with administrative fines actions. And when we did that, we received a motion to dismiss in one of the matters that was before the hearing officer. And Commissioner Scott issued he granted that motion to dismiss, issuing an order. And since that time, the department has no longer sought administrative fines. We have other authorities to address violations of environmental compliance, including issuing administrative orders and referring those matters to the Attorney General's office for civil penalties. But I just want the committee to be clear that since that time, we have not been issuing fines. We're here today. We were directed by the commissioner to fix this issue, to promulgate rules for the various statutes that do require rules regarding the administrative fines. These are the amount of the fines. Not all of our statutes require that. I just also want to note that. So this is the first of other substantive rules that you'll see coming before you to address this problem. And I just wanted to make you aware of that.
Thank you. Representative Lynn?
Yeah, so I just want to make sure I'm understanding. So you mentioned that this, Commissioner Scott had issued this decision to suspend collecting the fines in sometime post-pandemic. Am I understanding that correctly? Or either during or post-pandemic?
Post-pandemic, we resumed issuing, we issue a notice of proposed fine and hearing to the respondent. We have due process, obviously, and they have an opportunity for a hearing. And when we resumed that, there was this particular case that was brought forward, and the attorney for the respondent filed a motion to dismiss on the basis of the fact that the administrative rules with the schedule of fines was expired for that.
Okay.
And
So-
that motion was granted by Commissioner Scott, and we were directed not to continue that practice.
So what, I guess, if I understand correctly, the statute that was referred to earlier, which said that no rules can be enforced if they're no longer in effect, that statute was passed in 2015, if I understand correctly. And so I guess my question is, what was happening between 2015 and 2020 when the pandemic happened?
I'll continue, but feel free to hop in before my time there. But the department was taking administrative actions. They were proposing fines. They were in those pleadings. They were putting forth the fines that the rules were expired and that we were seeking fines in a court, using them as guidance. There were decisions issued by the hearing officer that was a designee of other commissioners where those fines were imposed, and that was the practice. So they're used as guidance along with our compliance assurance response policy.
Can I ask one?
Please.
Follow-up. Just one follow-up question. The advice that you indicated you received from the Attorney General's office, was that advice received before or after the 2015 statute?
Good morning, Judge Lynn. I was essentially the prosecutor of all of the administrative fine actions, the contested actions, since I started in 2004. So I was working for the legal unit in 2008 when these rules expired. At the time, I had no role in promulgating rules, but the unit administrator at that time advised me that we could continue to pursue administrative fines under the statutory authority of the commissioner to impose fines, even without the rules. And we continue to do so. We continue to do our fine actions in a very similar manner than we did prior to the expiration of the rules. And in almost every contested case, the commissioner's designee, I certainly noted it in my pleadings that the fine rules were expired. And in every decision that the commissioner's designee made, the hearings officer made for the 12 years that that particular one was there who was there in 2008, he noted that. He noted that that's exactly what the division was doing when it proposed the fine, and he took that into account in imposing the fine on behalf of the commissioner. So it was noted in every case, and I do want to add that more than one of our administrative fine decisions, contested decisions, which represents a minority of our administrative fines actions. Most of our actions are done by agreement, and they have all the information. We're very transparent. But as far as the contested actions, a couple few have been appealed to the Supreme Court. One in particular was appealed in 2020, and this particular point was not brought up, this very specific issue, but the court considered how we calculated a fine, how we proposed a fine, and how that fine was ultimately imposed. And it went through our compliance assurance response policy, and it went through our process in its deliberation and in the order, and did not find fault with it. So again, just for me professionally, I believe we've been doing the right thing, and I'm hard pressed to believe. I argued in the case that Attorney Monroe mentioned. I argued for the division that the motion to dismiss should not be granted. I argued rather vociferously because I've been doing this for quite some time, and but I really believe that the alternative, and frankly, it's the alternative right now, is for these cases to go to the Attorney General's office. And the civil penalties and the process is much more challenging than the administrative fine process, which is intended to be like a small claims process. And I have always been very transparent about the expiration of the rules and how we calculate fines and how we work out agreements. The compliance assurance response policy essentially tells people how I negotiate for the division. And that's online. That's public. That's a public document. So that's how it has worked, and that's the advice that I received through my administrator. I don't assume to know exactly what the Attorney General said. I don't believe their office said you can continue to enforce these rules. I believe, as it was transmitted to me, it was said is that the commissioner can continue to impose fines, and then we just continue to use the rules as guidelines.
May I ask
Yes,
just
please.
one other follow-up? So am I understanding from what you're saying that in addition to the statute that has been referred to that says the department shall issue regulations and establishing a schedule of fines, that kind of thing, am I understanding that in addition to that statute, there is another statute that just sort of generally gives the commissioner the authority to impose fines? Is that what you're saying? Or
We have many statutes that authorize the commissioner to impose fines, and they're basically subject matter oriented. So for instance, the case that was dismissed was a subsurface case, a septic system case. And so that was brought under 45A, 44, I think. 40. So in that statute, it says the commissioner has the authority, and many statutes read similarly. The commissioner has the authority to impose fines up to a certain amount, 2,000. In some cases, it's been raised to 4,000. In some cases, it's been raised to 5,000. And then in a separate sentence, it says the commissioner shall adopt a schedule of administrative fines. So it's separate, and I would argue that the statute doesn't say if you don't adopt the schedule, which they did years ago. If you don't adopt the schedule, that doesn't mean you can't impose the fine. And that's exactly what I argued in the objection to the motion to dismiss. a lot of our statutes say exactly that. And I surveyed other statutes of other departments, and a lot of their statutes are similar. We have several statutes that don't say that. Our wetland statute and our shoreline statute does not speak to a schedule of fines, and our air statutes have the matrix that you would have seen that was in our that is in our CARP, our Compliance Assurance Response Policy, that would have been in the expired Rule 610, and that is actually similar to the one that's at the end of this rule that's being proposed. You know, that matrix has been consistent, and it's in the air. A similar matrix is essentially in the air statute. So different statutes have a slightly different method for imposing fines, and again, it goes primarily by subject matter. And Attorney Monroe's idea has been to, instead of trying to redo the whole block of a dozen or more administrative fine schedules in what's essentially a procedural rule, ENVC 600, we're moving them to the subject matter rules. So now this schedule of fines will be in the has waste subject matter rules. So the idea, hopefully, is going forward is that it'll be just regularly updated as they update their rules. So that's the idea of, in terms of going forward, how we resolve this.
Director Morrell?
I agree that the statute in question for these particular types of fine gives the authority to the commissioner to impose fines. But that very same statute says the commissioner shall adopt a schedule of fines, which is what basically you have in front of you as a proposal. And this is a fundamental basis for rulemaking. If you don't have authority, I mean, if you don't adopt the rule, then the rule cannot be imposed. And that's what has been done, at least between 15 and 20, that they were imposing fines that they could not legally do under 541A 22(1).
Senator?
Thank you. So I guess, and again, this is a retrospective look we're looking at in this conversation, right? Not necessarily looking forward, but going backwards. I guess my question is, and maybe Judge Lynn may have a comment on this, but part of me looks at these rules as being a mandatory sentencing, for lack of a better phrase, right? There's a list of mandatory sentencing. And in any other instance, if we took away mandatory sentencing, it doesn't do away with a judge's right to still sentence. And so I guess my question here is, if we took away so-called mandatory sentencing like this, does it actually take away the agency's the overriding right that's allowed above to issue fines? And without the mandatory sentencing, does that automatically strike their ability to set any fine?
Well, it would conflict with the current statute that does require a schedule of fines. It can raise the issue of how the department determines what fine shall be imposed for a specific violation. The statute says up to $2,000, but how do they decide between $100 and $2,000? In the proposed rules, they say for this violation, the fine shall be this amount.
So the follow-up question would be, with the expiration of fines, I know historically we've had agencies issue refunds, and absent those rules, but given the larger authority of that they're allowed to set up to a $2,000 fine without the mandatory sentencing, so to speak, does that mean they have to issue the refunds?
Good question.
I think many of those, the programs, the administrative fines go into the general fund, just for your information.
In this case, the statute's pretty clear that proceeds of administrative fines levied pursuant to this paragraph shall be deposited by the commissioner into the hazardous waste cleanup fund established by 147B.
For this one. And that's why we're here to correct this today.
I mean, I'm not quite sure that the mandatory sentencing analogy fits here. I mean, but the other thing is, did I understand from a comment that one of you made? I'm sorry, I apologize. I'm not sure which of you said this, but that you were using, even when the rule was expired, you were sort of using the guidelines of the rule as sort of a template to decide what fines would be. And it really does seem to me that that supports what the director is saying, that the intent here of the statute, I mean, I suppose you could pull one sentence out and say, well, that gives general authority to impose fines, even if you don't have rules. But that, I don't know, it sort of seems to me that is it's an arguable interpretation of the statute, but I'm not sure that it's a good one.
I'd like to comment that, well, two things. First, did the Attorney General issue that guidance in writing? Not that you know of. Lovely. Also, I can see you're relying on that guidance and your expired rules in 2008, but when we specifically changed the law in 2015 to say that expired rules cannot be enforced, I'm very concerned that you decided on your own that you should ignore that change and simply continue working with your expired rules.
I don't. I sure hope that that was not intentional. I worked for the department for many years, and I would hope that we did not
I hope so
intentionally.
too, but that's certainly what it looks like to an outside person. I mean, we changed the law specifically to prevent expired rules from being enforced. And your department, for some reason, either didn't notice that change or decided to ignore it and kept doing what you had been doing. Is that a fair interpretation?
Well, I would assert that the same people that were directing me to do my job in 2008 were still there in 2015, including the commissioner, I believe. And that was simply not brought up. To the best of my knowledge, the intent was to, starting in 2006, because I remember the email, starting as far back as 2006, the intent was to do new rules, to readopt rules. And they had been worked on and off, to my knowledge, from 2006 through today. And in fact, in 2014, the new 601 through 605, which you just agreed to the repeal of today, was put in place. And they didn't really include a schedule of fines, but they spoke a little bit to some of the procedures of calculating a fine and bringing a fine action. And in fact, those rules that were approved in 2014 referred to, like, for instance, the expired 610, the matrix, or matrices in 610. They refer to expired rules. And in fact, that was one of the things that the very clever attorney who wrote the motion to dismiss in my case back in 2022, which ended our practice, mentioned that you can't even follow that rule because it refers to expired rules or expired fine schedules. So you can't even follow that rule, the 603 rule that talks about how we calculate fines. And those rules were approved in 2014, which of course I was very frustrated to see in a motion in 2022 because I was using the rules that I was instructed to use. But I will say that I find it, based on my life experience, hard to accept when you say we're enforcing the rules against the law, against the statute, because the fine schedule is just one part of what we use to decide which fine to propose. And like I said, the majority of our administrative fine actions are done by consent. And those almost always include some sort of discount because we're negotiating a settlement agreement. And when I bring a contested action on behalf of one of the divisions in front of the commissioner's designee, and I'm using the fine that we are proposing, that we are calculating, that we've calculated, the commissioner's designee has almost never imposed that same fine. They almost always take into account certain factors. They almost always discount it. So again, it's not like the fine rule said you got to pay $1,000 and we said, listen, where's our $1,000?
Madam Chair?
We don't
Yes, but-
issue, we don't issue
I
fines.
would like
Excuse
to
me,
introduce,
Senator Grant.
I would like to interrupt this right now. I at this time would like to offer a conditional, an objection to this rule. They're not ready. We need the department and we need our staff to go and reach consensus and come back to us. We don't need to do all of this, that it is not ready for us to work on. And therefore, whatever staff tells me is the right motion, either to object or to postpone, I am willing to make that after they tell me which one.
Senator Lang?
So, Senator Gray, thanks for the comment. Again, I don't know that there's any argument about the rule itself other than it's expired. So I think the rule is written as okay and a motion to approve would be okay. But the question is what happens with the retrospective aspect of all these fines that were issued while the rule was expired. Is that correct?
I thought that was correct until Attorney Barnsley just spoke in saying that there are other considerations they take and the fine amount can vary. The way these rules are written, I don't see that. It's this shall be the fine. There's no talk about mitigating factors or other considerations.
So again, I think that if this rule were to pass, these would be the fines and there's no mitigating factors because it says shall be fined. And so that would be the new law of the land, so to speak.
Well, so these rules would be the basis for which we would plead the fine, but the respondents still have a right to a hearing and they present evidence and the commissioner ultimately makes that determination. But the rules themselves would be the basis for the fine that we would propose.
So if I may, that's not what the rule says, because again, just pick any one of these and it says that if you violate, EVHW 30404F, the fine shall be $1,750 per inspection, not conducted. There's no wiggle room in there for what the fine is. It says specifically, this is the fine. There's no mitigation of that in the rules that you're proposing.
Well, the process is to provide for a hearing and
Absolutely, you get your due process for yes or no, it's guilty or not guilty, but you don't necessarily get anything other than, this mandatory sentencing of a fine, right? This is the fine if you violate this law.
I don't know that the mandatory sentencing analogy is.
Let's
Well,
not confuse
okay.
the issue with that.
Am I correct in interpreting that? These are hard and fast fines once this rule is adopted.
They appear to be, yes. There are oftentimes with other agencies where you will see mitigating and aggravating factors or other considerations to take into account when imposing fines. I know HHS often has something, if there is no dispute, if it doesn't go to hearing, then you're going to get an automatic 25% reduction in the amount of fine.
All right. Does DES have such a general rule that is, given us a schedule of fines, this is how we choose to apply it? Or what factors we consider when applying it?
We would apply the fine in the rule, and then we have adjudicative procedural rules as required under 541A30, and we would have a hearing. But the pleading would be what's in the rule.
All right, so you start with this schedule and go on from there depending on the negotiations, is that correct?
Or during the hearing process, they may produce evidence that we were not aware of.
Okay, well, I have to agree that I was prepared to approve the rule and argue your process or the history separately, but it sounds like there are things we need to understand as to how this rule is applied before we try to approve it. So, does anyone have a motion?
Can we postpone this? Is there a deadline on this?
October 30th.
So we could postpone this till next month and take this back up and let them submit a CA for changes.
Or some backup information on your procedural rules so that we know that this is not a mandatory sentence as it appears to Senator Lang, but rather the starting point for negotiations.
Right, may I just make, and I mean, it
Yes.
sounds like, I completely understand what you're saying in terms of the way the way fines may be imposed in any particular case. It sounds like you are not interpreting these rules. I mean, even if they were in effect, you wouldn't be interpreting them as being sort of mandatory, although, as has been pointed out by the staff, that seems to be the way they're worded. So if you want to have some, for lack of a better term, some wiggle room to be able to consider, various factors in mitigation or whatever, then the rules should probably say that, as opposed to simply, as Senator Lang points out, as to simply saying, if you do this, this is the consequence, no ifs, ands, or buts.
Yeah.
The rule ought to be, the language ought to be amended probably to say, if you do this, this happens, except that we can consider, but we can also consider other factors mitigating or aggravating, whatever. Would seem to me that would make sense. So I guess I agree with Senator Lang in terms of what we should do now.
Okay.
So I move we postpone this until next month.
Absolutely.
All right. Representative
We
Lang.
can do better.
Thank you. If I can just make one other comment, I believe that in the past, we've also, when there's been mitigating factors, looked to make sure that there's a structure so that they're implemented consistently. So I would be looking that when you come back, that there is a consistent way to implement those factors.
Or refer to your other procedures that talk about that.
So just so I'm clear, what is it you would like us to come back, come back? What,
Come back with something better.
Right. So again, I think the issue is that staff as well as myself think that your fine schedule is a fixed point, not a moving point. And you're saying it's being implemented as a moving point. So add rules to this that talk about why it's a moving point, what makes it a moving point versus shall be language that's currently in the rule. If you want to do that, if that's what if you want to have that variability in the fine based on what's fixed.
What I hear you saying is you want to basically have us put the commissioner's discretion. The commissioner has discretion to decide which fine to impose. Put that in rule, whether or not he can have discretion. Because I will tell you that I argue that the fine that the division is proposing should be imposed. But very often, the commissioner's designee, the hearings officer, takes into account the entire hearing, all of the evidence, all of the record, and then imposes a fine that is not always exactly what is in the fine schedule, even before these fines expire.
So I guess
Define
my
rules.
statement is that process needs to be integrated into this rule so that
And if
you
it's in a-
can lower.
If it's in a different rule, please point out what rule it's in. What we're concerned about is that, not Commissioner Scott, but some future commissioner will say, oh, the fine for this is $2,000, but this is my friend you're talking about, so we're only going to make you pay 200. If it's entirely at the commissioner's discretion without any guidance, then it's open to corruption.
Well, I will say the EMVC 200 is our process as attorney.
Then we,
well,
thank you. We would love to reference that as well.
okay, so would you like that in writing prior to the meeting?
Please.
For consideration? Okay, we will do that.
Director Morrell?
One thing that could be done is say, this is the standard fine. However, it is subject to change pursuant to the adjudicative proceeding based on factors, and then they could give 2 or 3 factors and then a general catch-all.
I mean, the other case that comes up is that some naive operator says, oh, fine's $2,000, here, okay, here's your 2,000. And somebody that's been around for a while says, oh, I'm going to appeal, and they all get knocked down to 1,000. I mean, that's the sort of thing that can happen with this kind of written rules. So please, the more information on your process, the better.
Okay, we will do that.
Okay, thank you. All right. Is there anything else? That's the last item.
So this is an objection response from the Department of Health and Human Services regarding the foster family care licensing requirements. There is one written comment in the objection response meeting packet that is posted online. However, after putting that packet together and posting and having additional conversations with the agency, I do have one additional comment that the agency is aware of, but I will go over that orally. But to start, just to remind the committee that the objection was based on 3 points. The first was the rule was unclear due to the agency not being clear of when the application is completed in order for the agency to issue a decision within 60 days to comply with RSA 541A29. Looking at the response, I did not see any reason for this point to be upheld. They did make a change to that. They made it clear when exactly this is considered complete, and then in the rule itself says that a decision will be issued after either the completion of that application within 6 days or within 60 days after receiving additional information should it be requested. So I think that point has been taken care of. The second point, that the signed acknowledgement in HEC 6446.06D1A may be against the public interest due to the lack of protection for the applicant's healthcare information when it is disclosed to the department's providers. The agency also addressed this in their response. They reworded the language to state that even if this protected health information were to be given to redisclosed to a contracted party, that it would still be under the protection of the state and federal law. The issue last time was there was a line in it that said that should this be disclosed, it could no longer be protected under the federal law. And in looking at that closer, the federal statute does state that if someone is going to authorize the disclosure of their personal health information, that the disclosure is required to say and notify the person who is authorizing the disclosure that the potential for information disclosed pursuant to the authorization to be subject to redisclosure by the recipient no longer may be protected by this subpart. So this subpart would be HIPAA. That's that statement that's in the certification. So the department has made it clear that this information may no longer be protected under HIPAA, which allows the doctor to disclose the information, but the information still will be protected under state and federal laws as they apply. So I think that also has been taken care of. So it's the last issue that I think still needs to be addressed, and that is that HEC 6446.14H may no longer be enforceable due to HB 408 becoming effective once it's signed by the governor. That bill was signed by the governor. It's now in statute as RSA 170E 27B. And in looking at the language, I think there is still some problems that may be fixable. The first comment, that is the written comment on page 7 of the objection response, I think could be fixed if it's reworded, because as it's written now, it says all household members who may be caregivers are required to have these certain vaccinations should they be caring for infants or children with disabilities. I think that needs to be reworded to make it clear that it's only adults who are caregivers, to ensure that 16-year-old, 17-year-old who happens to be watching the child acting as a caregiver is not required to have these immunizations, because they're not statutorily required and they're not required under the agency's rules for other children, other school-aged children, which would be in violation of this new law. So I believe that needs to be fixed. I have had a conversation with the agency. They agreed that that could be reworded better, and that they'd be willing to look into that more. The second comment I have that is not written in the packet is also an unclear comment, but based on the what is intended. It could also potentially be a legislative intent comment. So the issue is that the way it's written could mean two different things. The first is that the requirements in the rule, which is, the immunizations be consistent with the recommendations of the American Academy of Pediatrics, the Advisory Committee on Immunization Practices of the Center for Disease Control, another organization. I had originally read that to mean that the dosage amounts, the age that these immunizations have to be given, those type of requirements, those type of recommendations is what was intended. If that was the intent, then it is fine as written because the agency, well, it could be rewritten to make it clear, but the intent is fine because the agency does have a rule specifically stating that this requirement is for all children in the state, all school-age children in the state, and therefore would not be in violation of the statute. So that would just be a simple rewording. However, if the intent is that the recommendations would also include the types of vaccinations, that would be against the legislative intent of this newly enacted statute, because the statute says that children who are in the household, whether they are foster children or biological children, any child in the home that is who is essentially caring for these foster children, need to only be required to have the same immunizations in the same manner as every other school-aged child. And if these recommendations in the rule as written intends to have additional vaccinations, that is a legislative intent issue. So I had been in communication with the agency. Unfortunately, I didn't get an answer of what was intended with this particular paragraph, so I can't say whether it is simply unclear or unclear in legislative intent. I'm sure the agency can clarify that, but as I stated, if it's meant to be intended the first way, this could also just be fixed because by being rewritten. Otherwise, I would recommend that the committee look at making this a final objection based on that legislative intent issue.
Hello. Hi. Good morning, afternoon. Good morning. Allison Radmay, the administrator for the Administrative Rules Unit at the Department of Health and Human Services. Attorney Reichard is correct in her interpretation. That is more of a clarity issue with respect to the vaccinations required for the children. It is our intent that they only have the required vaccinations as the same as school-age children. So at this point, the department would actually like to request a revised preliminary objection to amend paragraph H2 and 3 to add adults before household members to satisfy the original unclear comment, and then add language to clarify that no vaccinations are required other than what is required for school-age children in our state.
Thank you, because I believe that is the legislative intent.
And now that the agency has requested a revise, the committee would vote on whether to issue that revised objection, and then the agency will have an opportunity to fix that.
Okay. Are there any other questions before we do that?
I'm sorry, can I just ask a quick question for Claire? I want to make sure I'm understanding. If we add if in H2 and 3, we add the word adult, does that somehow suggest that adults don't have to be, that to be a caregiver, you don't have to be an adult? And is that what is intended?
So for these particular set of rules, one of the reasons that it was unclear is because there's no definition of what a caregiver is. If there was a definition and it said only adults, then that would make it clear that that's what's intended. So I agree that, what is a caregiver is up for interpretation. However, by adding adult household members who are caregivers, I do not believe that it would make it sound as though only adults could be caregivers, because it's specifically speaking that these immunizations are required for this certain set of people, not that these set of people can only be.
No, I understand. So in other words, what I was concerned about is that somewhere else in this rule, it said only adults can be caregivers, but you're saying it doesn't say that.
Unfortunately not, and that's why it's unclear, yes.
Okay.
Got it.
Representative Leon?
Thank you, Madam Chair. And I do want to clarify, we're looking to also make sure that the exemption under 141C 20-C applies to sections 2 and 3 as well.
So if they put in adults in 2 and 3, that makes it clear that those immunizations are only required for adults and not for children. And the RSA 441 C20A is specific that the exemptions are for school-aged children and not for adults. I'm not clear about what statute would require or would exempt adults from certain immunizations, because I don't believe there's any law requiring adults to be immunized. Unless I'm misunderstanding your question.
Thank you. That was the big debate over the last few years about whether or not there was a religious exemption for adults. Currently, there are no mandates for influenza vaccine for adults or for anybody. And so then there's the concern about whether this would prohibit a religious exemption for influenza or for anything else. And I would want to make sure that that is clear. I will follow up if we do have a statute that specifically refers to adult religious and medical exemptions, which I believe we have.
And I can let the agency clarify. I believe that this rule is actually going to be brought before the committee again next year, because there are more revisions that'll be done. If that's something that the committee wants to address with them when it comes around again, that certainly is something that we can keep in mind and keep on our radar. However, with regard to, the objection, those 3 points are kind of what we're limited to at this point. That sounds like a new point that's being brought up, and unfortunately at this time, and Director Morrell can correct me, but I believe objection responses only have to address what's in the objection. So because at that time it's outside the scope, we could certainly make it a recommendation that that's something they consider when they come forward with their new rule, but I don't believe it's something the committee could really address at this time.
Director Morrell?
Yeah, excuse me, that's correct. Once you issue a preliminary objection, any response, the committee cannot subsequently add new items for objection unless the objection response itself creates a new basis for objection.
Yes, and just as a follow-up, I thought that applied to adults. That's why I was making this point. Not a problem.
And so, yeah, so by adding adults, it would address that original issue, whether or not an exemption for adults, once again, that may have been something that could have been brought up originally because it had specified all household caregivers, and that's not something we really discussed the first time around. However, if it's going to be revised to say adults only, I'm unsure if that would be a reason. I'm certainly, I could talk to the director about that.
I think that right now we're making very, very significant process. We'll work on the adult part as we move forward. And if I may make a motion to accept with all of these changes, or sorry,
No.
if I could move as suggested, I would.
Okay, so we're moving a revised objection so that the agency can make these agreed on corrections. And I'll second the motion. Is there any discussion?
Well, we'd have to appoint Jack.
Yes, Representative Grota, you're in for Senator Lang.
And just so the revised objection response, I understand the points for that, but did you also want to add on the recommendation that moving forward for new rulemaking that they consider whether or not adults should be exempt?
Yes, please.
Okay, sure.
Thank you.
Okay. Any further comments, questions? All right. Those in favor?
Aye.
Opposed? All right, thank you very much.
Glad we got that straightened out.
So to
That's
speak.
what we did. That's what we did.
All right. So, other business?
Under other business, you should have in front of you 3 different forms. For newer members, as part of the manual, we have a dozen plus forms that agencies are required to use for specific rulemaking actions. Because of amendments to House Bill, because of amendments to 541A instituted by House Bill 358, there are needed changes for the rules. These three that are in front of you need to be approved. They've already been approved by the Director of Legislative Services, but they need JELCAR's approval. We're going to have another 10 or so that will be before you at the October meeting. House Bill 358 does take effect October 3rd, but those other forms are not needed before the committee's meeting in October.
Okay.
Additionally, we have a couple of memorandums from boards, and I'll let Rebecca address those.
Before then, could you go, if we have to approve
Oh,
these?
I'm
Could
sorry.
you give us a quick summary of what the changes are to these rules?
Sure, I can do that. So first one is the cover sheet for the proposed interim rule, and you'll see there are some track changes. Like Director Morrill was saying, the form has been amended to comply with the new language from HB 358, and you'll see that number 9. It says it's requiring the submission of agency forms. Right above that, we've put in some new language, and that is not as a result of House Bill 358, but it is something that we thought we would do at this time. And that says whether the rules being proposed are implementing a state statute for the first time. So that would get at the situation that we had today with the fish and game rule. And we've added that same language on the interim rule notice. So that form didn't really need any amendments as a result of HB 358, but we did at this time go ahead and stick this new language in there, and you'll see that in number 8. And then on the notice for expedited revision to agency forms, this one has been amended to in compliance with HB 358. And there they've got to indicate what rule number is being impacted and whether or not the rule text itself is being amended or a readoption with amendment. And so we've also done some information, some explanatory explanations, if you will, how to fill out this form. So that's, new on the second page there. It kind of outlines for the agencies how to complete that, how to say whether or not the type of action for the rule is either an amendment or a readoption with amendment. So that's a quick summary of the changes to those 3 forms.
Okay. Does someone wish to make a motion to approve these rules?
So moved.
Seconded.
Okay. Any discussion? All right, those in favor?
Aye.
Opposed? Okay. And on to the letters from the agencies.
Yeah, so I'll make this very brief. The first one has to do with the Mechanical Licensing Board. During the last meeting, the committee had some questions about how the board establishes whether a person is mentally or physically competent to practice based on the application questions. This was the memo that was submitted by the board, and it essentially says that they rely on the questions regarding the criminal, whether or not someone's been convicted of any criminal, I apologize, and have a criminal conviction that relates to physical or mental component, whether or not they've had discipline in other jurisdictions based on physical or mental components. So those seem to be really the only set of questions that they rely on. There's nothing more in depth than that. And then the second one is from the Real Estate Appraiser Board. There was a question about whether or not the board had been collecting fees during the time their rules were expired. This particular memo explains that the rule that actually has the fees in it, which is RAB 306.01, actually did not expire. So those that rule that established what fees are charged didn't expire. It's simply the renewal process, and they further argue that under the statute, they have the right to collect fines for renewals. It's pretty clear that, a fee, not a fine, a fee,
Thank you.
to be collected. So that was all for those.
Okay. Director Morrow?
One other quick thing. Yesterday, we sent out a memo to agencies summarizing the changes to 541A from the past session. There were 4 bills. 2 of them were very minor and very specific. HB 358 was the big one, also HB 266. If the committee members would like a copy of the memo is very long and very detailed. It shows each section of the bill and then our comments on it, but there is a 1-page summary.
I'm good for 1 page.
Yes, would you please send
Quite
the
candidate.
one-page summary to the entire committee? And I'd like a copy of the full extravaganza.
All right.
Anyone else who
I'd
wishes?
love the extravaganza as well.
I'll take the full
Okay.
one as well, please.
Yes.
Yeah, as will I.
Okay.
The
Fine.
long one is an attachment to the email, and the email itself has the summary.
Okay.
That's fine. We can ignore it once we get it.
I didn't hear that.
So, Madam Chair, do we need to make a motion on the remaining documents?
No,
Okay.
the preliminary objection responses have not yet been received, so we're not going to do anything with them.
Madam
Director?
Chair, are we going to cancel the continued meeting?
I believe so. We haven't postponed anything to it. All right. So our next meeting will be the regular October meeting, which is the 21st.
I think it's the 16th or 19th.
The 19th. Okay.
19th.
The 19th of October will be our next meeting. Thank you all for coming. If there's no objection, we will adjourn.
Don't object anyway.
No objection, no objection. October 19th.